Call to order the Oklahoma City Board of Adjustment meeting for October the 20th, 2011. Our first order of business would be to receive the minutes of the October 6th, 2011 meeting. I would entertain a motion.
Second.
I have a motion and a second. Please register your vote. They are approved. I would entertain a motion to approve receiving the minutes of the October 6, 2011 study session.
So moved. Second.
We have a motion and a second. Please register your vote. Those are approved. We have a request from the applicant, Doug Friesen, to move his case to the first case that's heard. I would entertain a motion to move item number 9, case number 13244, to the top of the agenda.
So moved. Second.
It is approved. Mr. Friesen?
And thank the board for the courtesy. In looking through items 1, 2, and 3 that we're here for in reference to an approval on, and I guess a continued request, I believe that all of the items will be done at the completion, by the completion of today, with the exception of the painting, which will be done by Monday.
So the outside contractors that you had hired, everybody showed up on schedule and the work has proceeded?
Everybody has showed up on schedule. The west side is done and the east side with all of the roof brackets and fascia and all of that should be completed by conclusion of business today. Painting will immediately start and it should be done by Monday.
Could I ask, Catherine Montgomery is expected at this meeting. Are we expecting her soon enough to testify during this portion of the...
She may need to be here later.
Okay, then we may hear Catherine after you've excused yourself because of your other commitment this afternoon. Do any of the other board members have questions at this point? I think, what we're looking at is probably, continuing this in light of the progress that you're telling us you made. We'd like for Catherine to corroborate that. The other thing that we'll need from her is when HP will hear the items that we remanded back to them at our last meeting, and then at that point, it will set a date for us to reconvene and to ask your attendance at that point. And so if we can do that, and just, staff will notify you when we've had Catherine's testimony.
Does Mr. Friesen know when HP will have that hearing? Do you happen to know the date for the hearing?
I do not know the date for the hearing on the HP yet.
They meet the first Wednesday of every month, but we're not clear yet if it'll be November or December.
Do we need to go ahead and continue it to a date and then let that date be subject to revision? Would that be the fair thing to do? Okay, then we'll go ahead and vote on the continuance after we've heard from Catherine and she tells us when HP, and then staff will advise you of what that date is. Okay?
Thank you.
Thank you very much.
Excused.
Pardon me? I'm sorry. Could I ask you to wait just a moment and invite Mr. Dell forward, please?
Thank you. I'm Brian Dell of 528 Northwest 17th Street, and I would like to tell the Board of Adjustment that from the observation of my kitchen window, things are looking better. As was stated, there's somebody been working on there with a lift for the last 2 or 3 days. The one observation that I would make is that the supports that have been put in there are non-conforming. They can be made to conform, but now they're solid without the typical thing that has been throughout that neighborhood. But I'm hopeful that because they can be made conforming, that all of the things will be done and it will be appropriate.
We'll need to make sure that Catherine is aware of what you're referencing, and we've remanded back to HP the items that were non-conforming for their judgment for us.
I'll email her that information.
Okay.
Thank you very much.
Thank you, Mr. Dell. Mr. Friesen, thank you very much. Next case, please.
Item number 1, case number 13463, request for use variance of Barron Exploration Company for permit to drill an oil gas well located at 5910 Melrose Lane.
If you would, state your name and address for the record, please.
Sure. My name is Jack Dake. I'm land manager for Barron Exploration Company. We're located in Edmond at 107 South Broadway, and this is about my somewhere between 70th and 75th permit to be before you.
Why don't you speak to your application?
All right. This is on the existing well site that exists at Melrose and MacArthur, just north of the railroad and south of Melrose on the west side of MacArthur. The site was established in 1989. The well was drilled in 1990, completed in 1992. It's known as the Harris Keller well. It's an interesting site. It's the property there is a original homestead. Our company bought the site and the well, and we have additional drilling planned there on the existing site. Access is from Melrose Avenue on the existing access that has been there for 25 plus years now, something like that. And there's a natural gas pipeline that serves the site, although the line currently is being relocated due to the city's water drainage canal that is being put in east of Ann Arbor all the way down to Tulsa, and where it turns south there. And so there's a relocate in process on that. Yeah, we anticipate drilling to occur possibly as early as December, but more likely will be in the first quarter of 2012. Rig availability is a really severe issue in central Oklahoma right now. And basically it's just, again, another one of the type of wells that Barron does, and which is kind of our niche or expertise is drilling in the city area. Barron's first well in Oklahoma City was in 1958 on North Pennsylvania. And so we have a long history of operations in the city limits.
And I'm assuming that you're here to speak to all four of the applications.
Yes, I am.
And what I would suggest to the board is we can go ahead and discuss any issues that we have regarding these four applications, and then we can do a separate vote on each, if that's your desire, or we can save our discussion.
That is fine.
Any discussion, questions from other board members? In that case, I would entertain a motion.
Motion to approve items 1, 2, 3, and 4.
We'll need to do them separately, so item one. This will be
Item
a
one.
motion to approve item 1.
Second.
Motion and a second. Let's register your vote. We are approved for that. Item number 2.
Approve item number 2.
Second.
A motion and a second. Please register your vote. You're approved. Item number 3.
Approve item number 3.
Second.
Register your vote. Item number 3 is approved. Item number 4.
Motion to approve item number 4.
Second.
Motion and a second. And register your vote. You are approved.
Okay, thank you. All right.
Item number 5, case number 13467, request of Robin Ridge LLC for a variance to permit a single-family residence encroaching the 20-foot platted front building line located at 15616 Blue Jay Drive.
Good afternoon. I'm Kendall Dillon with Crafton Toll, representing the applicant. And the purpose of this application is, or this lot actually is in the Robin Ridge Section 3 addition, and the builder has inadvertently built the front of the house approximately 2 feet into the front setback. And therefore, we are unable to obtain a occupancy permit, so therefore therein lies our hardship. If you look, this lot is somewhat unique in the fact that it lies in the middle of that eyebrow cul-de-sac and therefore in a curve. But the good thing about it is because it's in a curve, then visually you cannot see the encroachment. And also we have ample distance between the front of the garage and the edge of the sidewalk so that we will not be blocking any sidewalks, and therefore there should be no impact to the public. And because of that, we feel like that we meet your standards, and we'd ask for your approval.
Any discussion?
I'd make a motion to approve the variance.
Second.
Motion and a second. Please register your vote. You are approved.
Thank you.
Item number 6, case number 13468, request of First American Title and Trust for a variance to permit a single-family residence encroaching the 20-foot platted front building line located at 7328 Stinchcomb Drive.
Again, Kendall Dillon with Crafton Toll representing the applicant. This application is very similar to the previous one. The builder has inadvertently built just the corner of the house, approximately 18 inches into the front setback. And again, it's somewhat unique because you can see that the lot fronts into a curved intersection, so there's a curve on the north and a curve on the south that's connected by a tangent. And again, we will not be blocking, there's ample distance between the garage and the sidewalk, so we'll not be blocking any sidewalks and should not have any effect on the public. So again, we'd ask for your approval.
I'd make a motion to approve the variance.
Is that for the front and the side yard setback?
What actually, they built the house kind of skewed. So what we've done is we were fortunate that the lot to the south is vacant and owned by the developer, and he has agreed, and we did a lot split, which we've already obtained approval for. So now we're in compliance with the lot split. The only thing that we need, obviously, we have a problem with is the very corner of the house, 18 inches of the corner of the house encroaches into the front setback.
Okay, so when you redo the plat, you're going to be at least 5 foot on the side yard.
Correct. We already have obtained a lot split or a deed approval from the staff that basically takes the 5 feet from the lot in the south and puts it into, or actually we did 2.5 feet to the lot to the north so that everything adheres to the code except for, once again, the front encroachment.
Now, I'm assuming we're okay on the width of that lot also? Okay. Second.
We have a motion and a second. Please register your vote. You are
Thank you.
approved. Thank you.
Item number 7, case number 13469, request of C. Barrett Detterman for a variance to permit a residence encroaching the 90-foot platted front building line and to allow an accessory building exceeding the maximum square footage requirement located at 4400 Amethyst Circle.
Name and address for the record.
Barrett Detterman, 4400 Amethyst Circle, Yukon.
Would you like to speak to your application?
I would. I'll try to make it brief. Purchased the home approximately 3 years ago with the intention of building a shop. I've been collecting cars for a while, specifically Mustangs. Looked very carefully into the covenants of the various neighborhoods that we were looking to either build or purchase in. The covenants in Gemstone Acres states that the shop or accessory building can be up to 150 square foot of the residence, 150% of the square footage of the residence, which our house is approximately 2,500 square feet, allowing for 3,700. I wasn't aware of the city code until I sent an email to the president of the HOA to inform them of my intent to build a 50 by 60 by 16, which would far exceed the covenants, obviously. Was that time made aware that I could request a variance. Did some research, actually looked at the minutes of every meeting for about the past 5 or 6 years to try to find similar instances of people on similar sized lots, residential, requesting a variance for a accessory building. Found that 3,000 to 4,000 was excessive and wasn't going to happen. Scaled mine back to the minimum I felt would work for my application, and also made sure that it adhered to all setback requirements as well as height requirements for the city, which is 12 feet now instead of the 16 I originally planned to do. As to the front of the house encroaching, bought the house that way, wasn't aware of anything of the matter, and a matter of fact didn't find out about it until I requested the variance for the accessory building and was informed that it'd probably be a good idea to kill 2 birds with 1 stone. As you can see, the house sits a little bit at an angle. There's a 3-car garage on the northwest corner, and that's basically what extends out, I think, approximately 10 feet. They put 20 on there, I'm sure, to be safe, but there's still a significant yard. The lot is 1.18 acres, so it looks good, and there aren't any issues there, I don't believe.
In your application, you noted that when you purchased the property, you were concerned about the neighborhood covenants,
Yes, sir.
and that was just whether the covenants would allow the accessory building.
Correct, and the size and construction, et cetera. The covenants do require the front, the side that faces the street, to be completely bricked,
Better not.
which will be done. It'll conform to all neighborhood covenants I want to fit in. I've included some photos of every shop in the neighborhood. There are 9 or 10. I don't know that they all conform to code, but I'm not, I don't know that any are bigger, but I don't know that the setbacks are all right, et cetera. But it's not going to be an eyesore. I live in a cul-de-sac, as you can see. Both of my adjacent neighbors, I've discussed it at length with them. Neither could be here, but they've both expressed that they were behind me 100%. Also, it will be set behind the house to an extent because of the location of the home on the lot and the orientation of the home and the fact that it's a pie-shaped lot.
I guess the question I'd have, is there any opposition to this application that you're aware of, either through the homeowner association, an adjoining neighbor?
No, sir. I copied, and I didn't include it with what I sent the board, but I have an email, the original email I sent the president of the HOA. Again, that's how I was informed that the city code was 1,250, or 2.5% or 1,250. I emailed back to respond that I amended it to 40 by 50 by 12 and was going to request a variance, and his response was, great, if you get it, let us know, and no problem. And again, I talked specifically to my neighbors to the, I guess, north and south technically, and we're friends with both of them, and they said, hey, hope you get it, knock yourself out, we don't care. We hang out a lot. They both have pools, and we enjoy hanging out.
So I guess, you know, when he bought the house, he knew he was going to have the 7 or so automobiles that he wanted to store. He thought that the guideline he was going to need to adhere to was the 150%, you know, from the homeowners association. He was unaware of the requirement from the city, which restricts the size of it.
And it's kind of an odd area. It's a Yukon address. It's Mustang Schools, and I'm before you today because it's Oklahoma City, everything else. So I had no way to know that ahead of time unless I would have tried to get a permit at the time, and I wasn't near ready to build it, unfortunately, at the time. So it's taken me a while to get finances set up.
So the accessory building is not started yet?
No, sir. It was really close to being, and I got an email just in time to hold off. And again, if I had started it, I would have started a 50 by 60 by 16, and it would have been way too big. But I've changed a little bit of what my plans are for the building, and the 40 by 50 will be sufficient.
So why do you need the building that large? What are you going to do in the building?
Cars. I currently have 2 quote-unquote regular vehicles. We have a Ford Edge and a Ford Ranger. I currently have 5 Mustangs and another one ordered, as well as all the lawn equipment that you need to maintain a lot of that size, you know, riding lawnmower, edgers, weed eaters. I also race my cars, a couple of them, so I have extra sets of tires, wheels, different parts, and it takes a lot of real estate to store all that. And having the necessary space between the cars to not have to worry about if I'm running into one or dinging one. They're all collectible to some degree, some more than others. But I think very highly of my vehicles, and it's kind of a passion and a hobby that I enjoy a lot.
So it's going to be a mechanic shop, really?
Well, not in a technical sense. It's going to be it'll be for storage and parking. I will tinker with my cars. I do like to work on them myself a little bit, but it's not going to be, you know, Barrett's Garage, or I'm not going to be doing service out of the shop or anything of that nature. It'll be mine and mine only.
Conceivably, that building could be another half the size of that. If you put a second story on it with a gambrel roof on it, no one would ever know that. I'm a little skeptical in approving. I think there's a reason for the size on 1 acre tract, and I think it's just exactly to prevent some of the things that you're trying to do there. And
with all due respect, sir, most people don't collect cars as I do, and I realize that's unusual, but that's what I'm into. Some people collect stamps, some people collect animals. I collect cars and enjoy them thoroughly. And again, it's not intended to be any kind of a shop or a business of any kind. The covenants prohibit that. And have no need for that. I am the general manager of a car dealership. I've got a facility if I need a car worked on to that effect. I don't think the roof will allow the height required to put a second floor in it.
And with a 16, you're asking for 16?
No, sir. I amended that to 12-foot walls.
Okay.
To stay within code. The only codes that I'm asking for a variance for is the square footage. I amended, the setbacks are all in line. the height is in line, et cetera.
How many cars will you have in the building at one time? What do you,
For now, 5, and I have a 2013 ordered, so then it'll make 6.
His application, what he wants to do is in compliance with the requirements of the homeowners association, where he's not in compliance, and the variance request is, he wants to build a 2,000 square foot building, and he's allowed, statute allows a 1,285 square foot building. But he's excluding, the restrictions in the statute. The homeowners association would have allowed him to build an accessory building of up to 3,700 square feet, which is a sizable structure. And I think you understand, the purpose of these statutes is for the protection of the community and to try to make sure that you don't end up, with somebody in a neighborhood doing something that adversely affects the neighbors in terms of, their quality of life and their potential resale values and so forth and so on.
In light of the fact that the homeowners association does not oppose this, his neighbors do not oppose this, and he has no opposition here today, I'd move to approve the variance.
I'm going to reluctantly second that motion, okay?
We have a motion and a second. Please register your vote. You are approved.
Thank you.
I want to acknowledge the presence of Catherine Montgomery and ask if we can hear one more case briefly, and then we will visit with you.
Item number 8, case number 13447, request to Better Business Bureau for a variance to the landscaping and fencing requirements and to allow gravel parking located at 17 South Dewey Avenue.
Please come forward. Name and address for the record.
Ladies and gentlemen, I'm Richard Hasley. I'm an attorney here in Oklahoma City, and I have my client with me today, Miriam Abenesh. She is the owner of property located at 617 West California Street here in Oklahoma City. What this is all about is the Better Business Bureau has filed an application for a variance, and our understanding by looking at that application and my client talking to the Better Business Bureau, they intend to run a fence immediately up to and about 3 feet away from my client's property. To give the chamber an idea, my client's property is a small 2-story, 5-unit apartment complex, and her unit faces the south on California Street. Better Business Bureau owns the property immediately to the east. In 1991, a gentleman by the name of Ray Pelfrey owned my client's property, and he immediately constructed a roadway on the east side of that property for the benefit of his people, his tenants. He thereafter sold the property in the mid-90s to a couple who continued to use that roadway exclusively for their tenants in that property. My client bought the property in the mid-2000s and continued to use that as an entrance and exit for her tenants. She actually thought she owned the property. As it turns out, she did not. It's a 10-foot strip of land in there that Ray Pelfrey had paved, and it continues to this day to service the tenants in my client's property. This all came about, and my client discovered that she didn't own the property when the Better Business Bureau filed their application for variance. Before hiring me, Ms. Abenesh went to the Better Business Bureau and tried to work out some sort of an agreement. That was not successful. I filed the application or objection in behalf of my client on August the 25th and served a copy of it to the Board of Adjustment. And thereafter, I received a letter from the Better Business Bureau. I'm sorry, I've misplaced it. I had it here. But in effect, and it came from the president of the Better Business Bureau, and he said that he acknowledged receiving a copy of our objection and that he had no further comment concerning the allegations or the reasons that we had set out in our notice to the Board of Adjustment as to the objections. I waited until the last minute in an effort, before I filed the lawsuit, in an effort to try to reconcile this matter. The Oklahoma statute, there are two that come into play here. One is if you acquire someone's property, if you occupy, and the case law says openly and notoriously for 15 years, then you can acquire that property by adverse possession. There is another statute in Oklahoma that gives you, if you use it, as my client has done for 15 years, and her predecessors, and that predecessors can be stacked on. If you use it as a driveway for 15 years or longer, then you acquire what's called a prescriptive easement to that property. That's what's going on here. So on the 17th of October, I filed a lawsuit in the District Court of Oklahoma County. Patricia Parrish is our district judge there. I've tried several cases before her. She manages her docket very well, and I anticipate the end of this is going to depend on her docket. I anticipate probably a one-day trial. I anticipate that it can be brought before Judge Parrish in 6 months or less. I cannot guarantee that. I can tell this chamber that my docket allows that. I will push it as fast as I can and make it happen. I have talked personally with Ray Pelfrey, the gentleman who built the roadway in there in 1991. He confirms what my client tells me. The road has been there and has been used solely by the tenants of my client's property since 1991.
I have a question for you, too, and I appreciate the timeline. That was going to be a question for us, is when you thought this might be heard. But the property went from Mr. Pelfrey to the Lees to your client. Wouldn't it be customary when the property was transferred for there to be some sort of a survey that would have uncovered where the property line should have been?
We don't have one.
But isn't it customary? I mean, I'm not an attorney, but isn't a survey often a part of a transaction and that would have identified what your property lines, in other words, so that you knew what you were buying?
Well, my view, and I don't know the answer to that, sir, but my view of that is even if it belongs to the Better Business Bureau, the fact that my client has used it solely for her use and the previous owners have done the same thing, that statute is pretty clear.
And I understand, and that'll be a matter for the municipal court to sort out. Do we have a representative from Better Business Bureau with us today? The latest continuance that we can offer you at this point is February the 16th of 2012. And it doesn't sound like that's probably adequate for the case to be heard. So at that point, you would reappear at that meeting, and there may be a more accurate timeline available on when it was going to be heard, and you could inform us at that time.
Okay. February 16th?
February the 16th of 2012.
Thank you.
We're not quite done yet.
I guess what we need to do is make some type of motion to continue this proceeding to a later day, and based upon his representations that he is hopeful to have this adjudicated within 6 months. Can we set it out 7 months from this meeting?
No. The last date that we can continue is what's part of the 2011 calendar that's been approved. We haven't approved anything else. So we can continue it to February the 16th of 2012. he would appear back before us at that time, and he might be able to provide us a more accurate timeline on when his case was going to be heard in municipal court. So
Do we need a motion on that?
we do need a motion on that.
I'd so move.
Second.
A motion and a second. Sir, you are approved, and we will see you back February the 16th of 2012.
Thank you, sir.
Thank you. I would like to invite Catherine Montgomery to come and speak on agenda item number 9, case number 13244.
Thank you.
Catherine, since you weren't present when Doug testified, he indicated that the contractors, the outside contractors they'd hired have been there and have been working, and that there appears to be substantial completion on the items that they were working on.
There does. I've provided for you today the photos where we left off last time, October 3rd, and then I went back on October 11th, and October 18th was printing when I started walking over here, so someone's going to bring that over. I think that's important because it does show that there's been substantial work completed on the east side, and as of Tuesday, they were beginning work and had accomplished some of that work on the west side. And, I didn't go back by today.
We remanded some items back to HP. Do you have a sense of when they might hear?
Yes, we've got them scheduled for the November 2nd meeting.
That quickly, good. So is it your sense that we're headed in the right direction and that the homeowner is making the progress that we had anticipated and hoped for?
Yeah, there's definitely progress that's been made over the past couple of weeks, and then with the items that are being heard for recommendation from the HP Commission on November 2nd, that'll help resolve some of those issues and point that in a direction that seems to have a plan.
We meet the next day. I'm not sure that it's fair to expect them to have a recommendation prepared for us that quickly, but if we continue this to December the 1st, that gives them a chance to prepare their findings and have...
Yeah, actually, we'll know that day, and it'll just be a matter of generating a memo for the record.
Okay. Then, Board, I would say we have, the ability to continue this to November the 3rd if you don't feel like that's a timeline that's...
I'd go for November the 3rd.
Okay.
The one thing I would mention, because you weren't here when the matter was first heard, the neighbor mentioned that there were certain supports that he believed were non-conforming, and will that be a matter that will be addressed by HP?
That hadn't been on the agenda for HP because those items hadn't been completed at that time, and they're still working on those. I guess he's specifically talking about the brackets that are currently being constructed. Okay. And they're currently being constructed, so I don't really have an opinion on them yet.
We asked him about that, as we were wrapping it up, and he indicated he would send you an email, and that may be something where, you can help us make the call. It may be something that needs to be, that we need.
Yeah, at the rate they're going now, we'll definitely know more about that by November 3rd.
Okay.
I'd make a motion to move matter 9 to the November 3rd meeting.
Second.
Motion and a second. Please register your vote. That is approved. Staff will inform Mr. Friesen of our next meeting date. We had a motion to approve the 2012 calendar, but the attachment in our packet was not correct, and so we're going to defer action on that till our next meeting. If there's no other business that I'm aware of, I would entertain a motion to adjourn.
Move to adjourn.
Second.
Please register your vote. We are adjourned. Thank you.